Thank you for joining Jennifer Schaus and Associates in our 2019 Webinar Wednesday series. We're coming to you live from downtown Washington, D.C. Our webinars are every Wednesday, and you can find the upcoming schedule on our website. Past webinars and all recordings are also on our website and on our YouTube channel, along with over 160 other recordings on federal contracting topics. All are complimentary. If you have questions for our speaker today, you can email them directly with the contact information you'll see on the last slide. This is just a little bit about us. We are a Washington, D.C. based firm and provide services for federal contractors. This ranges from market analysis reports to proposal writing and also postal award compliance. More information is on our website, so please visit us there. We do offer advertising in our newsletter, so you can reach out to this email if you'd like more information on that. All right, our speaker today is Alexander Ginsburg, and I believe we have one more speaker with us, Megan. Here we are, Megan Doherty, and they're going to be covering legal aspects of an M&A transaction. Thank you for joining us, you guys, and I'm going to go ahead and hand it over to you.
Great. Thanks very much. And as Mallory said, we're going to talk a little bit about legal aspects of an M&A transaction in the government contracts space. I think we can do the next slide. And the next one. And here are some common questions that a lot of companies and others would like to know about government contract M&A, and we'll try to answer these questions. The first is, can one sell a government contract? What does novation mean? It's a term you hear a lot in the government contract M&A space. And when is it required? How long does a novation take, and who decides it? Who decides whether to approve it, rather? What are the risks associated with GovCon M&A? And is there a way to structure an M&A deal to account for those risks? And so we will attempt to cover each of these 5 questions. Next slide, please.
Thanks, Alex. So one of the first questions that a contractor has to ask itself when it is contemplating entering into an M&A transaction is how they want to structure the deal. And the 2 traditional deal structures are an asset sale and a stock sale or equity sale. Traditionally, asset sales are considered to be preferable to the buyer because the buyer can limit the liabilities that it assumes through the purchase. And an asset sale involves the actual purchase, transfer, and assignment of a company's assets. So the company's real estate and its equipment and its contracts, including its government contracts. In a stock sale, the assets are not actually transferring from one company to another. Rather, the buyer is purchasing the stock or the control of the company. And so in that case, since no contracts are actually being transferred or assigned, in the government contract space, this is significant because novation of the government contracts are not required where they're not being transferred. Therefore, a lot of government contractors prefer to structure their M&A deals where possible as stock sales as opposed to asset sales and avoid the novation process altogether. And we'll get into a couple of reasons for why the contractors would be interested in avoiding this process if possible. Next slide.
Great. And so here we have an overview of the novation process, starting with the reason that a novation is required. And it's a little technical, but the answer to the first question on our overview slide, can you sell a government contract? The answer technically is no, because the Anti-Assignment Act prohibits prime contractors from transferring government contracts to a third party without government consent. And that's where the novation process comes in. And we have a citation to the Federal Acquisition Regulation, Part 42-1204, which sets forth the requirements for novation approval. The government, as part of this so-called novation process, may, when it's in the government's interest, recognize that third party as a successor in interest to a government contract when the third party's interests in the contract arises from some kind of asset sale. And you can think of the types of asset sales as broadly falling into 2 categories. One is a complete asset sale a full sale of an entity where one entity sells all of its assets to an acquiring firm, and that first company, the transferor or the seller, basically ceases to exist. So that's one type. And then there's a partial asset sale where, and that can range in size. It can be selling one division of a company. That's pretty typical. And sometimes you even see companies try to sell just the specific portion of assets devoted to one or two government contracts. And that's when you have some tension, as Megan will discuss in a moment. But the Federal Acquisition Regulation provision that we cited goes into great detail about what requirements a government contractor needs to meet in order to ask for the government's approval for novation. So next slide, please.
So what are some practical considerations when you're novating a government contract? Well, the first question is who decides whether to approve the novation package? And the answer to this is the administrative contracting officer. We get questions from clients all the time if they have multiple government contracts regarding whether they need to submit a novation package to all of their contracting officers. And the answer to that is no. It's the ACO who decides to approve or deny the novation package. If you don't have an administrative contracting officer, then the contracting officer for the contract that has the highest dollar value is the contracting officer who will approve the novation package. Now, if we're in a scenario, as Alex just discussed, where it isn't all of the company's assets that are being transferred, but rather just a smaller portion of the assets, or perhaps even just a single contract in the assets that are used for performance of that contract, then you would submit the novation package to the contracting officer for the contract that's being transferred. And so because it's the contracting officer who ultimately has the power to decide whether the novation will be approved, contractors sometimes think it's a good idea to have a conversation with the contracting officer in advance to try and move the process along. And that's something that is really a business decision on a novation by novation basis. The next question, and this is probably the question that we get most often, is how long does the novation process take? Unfortunately, there's not a crystal clear answer to this. The FAR does not require the novation, a novation package to be approved or denied within a certain period of time. I have seen in very few cases, but in a couple of cases, a novation package get approved in as little as 3 weeks. And we have also seen situations where it takes over a year. And so there really is a significant amount of variance in the amount of time that it takes for a package to be approved. And there are a bunch of things that a contractor can do to try and move the process along more quickly. As I said, you can speak with your contracting officer in advance to try and understand exactly what the contracting officer needs. You can put together a really good package that is very complete and contains all of the documents that are required in the FAR clause from the previous slide, 42-1204. You can also be very responsive to the contracting officer's questions, and this often requires effort by both the seller and the buyer. The contracting officer may have questions about what you submitted. They may have questions about the buyer's ability to perform the work. And so we would recommend when you're entering into an asset purchase agreement that will require a novation of contracts that you include a clause in your purchase agreement that requires the parties to cooperate to timely respond to any inquiries from the contracting officer, because that will help the process to move along more quickly. The final question we have here is, are there unique risks when only a portion of the assets are being transferred? And the answer to this is yes. Maybe one of the most significant risks is the risk that the contracting officer will not believe that all of the assets that are being used to perform the contract are truly being transferred. And so the government does not approve sales of naked contracts, as they're sometimes referred to, where you're just selling a contract without selling any other assets. And so it's very important that both the purchase agreement and the novation package outline the other assets that are being transferred so that the government can feel comfortable that this isn't a naked contract sale, that it really is a transfer of the assets, and that the government can recognize that as permitted by the FAR. The other risk here is comes when we're talking about IDIQ contracts. And here there has been a lot of case law out of the Government Accountability Office, GAO, over the last year or so, dealing with situations where a contractor sells an IDIQ contract and submits a novation package. And before the novation package is approved, an RFQ is issued for a task order under the IDIQ contract. And the question is, what happens then? The seller technically still holds the contract in the eyes of the government. And so how can the parties go ahead and bid on that work, even though the novation package hasn't been approved? The most significant cases that have come out recently on this are the Wiley Laboratories cases. And in this case, an RFQ was issued under the Oasis IDIQ vehicle. Wiley had executed an asset purchase agreement shortly after the RFQ was issued, in which it agreed to transfer all of its assets and liabilities used in relating to or performance of its Oasis contract to Grant Thornton. Grant Thornton was interested in bidding on the opportunity that was in the RFQ, and so Wiley went ahead and put in a proposal. And in its proposal, Wiley explained that Grant Thornton would be performing all of the work under the contract, under the task order, because its contract had been transferred to Grant Thornton. Wiley then went ahead and filed a pre-award bid protest objecting to some of the terms of the solicitation, and the government asked GAO to dismiss the protest, arguing that Wiley wasn't an interested party because it didn't have any economic interest in the award decision because Wiley would not actually be performing on the task order. GAO agreed with the government and dismissed the case and found that because Wiley's proposal made clear that it did not intend to perform the contract, that Grant Thornton would actually be performing the contract, that Wiley wasn't an interested party. Following the pre-award protest, proposals were submitted, and the government awarded Wiley an outstanding technical rating, but disqualified it from the competition on the basis that there was significant risk involved because the novation package had not been approved. The government held that it really didn't know who would ultimately be performing the contract. Wiley filed a second protest, and GAO denied the protest and agreed with the government and found that the assigned ratings related to the experience and capabilities of Grant Thornton, not of Wiley, and that it was reasonable for the agency to find that there was considerable risk that either Wiley could switch out Grant Thornton as the party that would be performing, or that the government just wouldn't approve the novation. And so what these cases really highlight is that when you're transferring an IDIQ contract, there is risk that such a task order that's issued under that may not be awarded to the buyer on the basis that it's not clear who will perform the contract if the novation package hasn't been approved. Next slide.
So as Megan said and gave the example of the Wiley Labs case, agencies have significant discretion to disqualify proposals that are pending during the novation approval process. And so parties to a government contract asset sale must think really strategically to limit that risk. And the ways that parties can think strategically, one, are to try to time an asset sale explicitly, not to have any key proposals that might be pending for a key opportunity while the asset sale is moving forward. And that's the easiest way to eliminate risk, and there are good ways to figure out how to proceed with the transaction in that light. And in addition, if that's unavoidable, for example, there are significant ways to expedite an novation process to try to make sure it's already resolved by the time a proposal might need to be submitted, for example. And one way to do that is certainly to know the requirements inside and out, to know what exceptions might exist to the sort of letter of the regulation. And that's something that Megan and I deal with a lot, is knowing when the FAR calls for something explicitly, but 99% of all contracting officers don't actually expect small business, for example, contractors, to have that level of documentation. And then the last way, in sort of the most strategic way to deal with this problem, is to give extremely careful thought to the treatment of proposal assets, or sorry, contract assets within a proposal. And there's a great case, sort of the opposite or doppelganger or something of the Wiley Labs case, another case at GAO called Enterprise Services. It's a protest from 2018 where there were several protests against the Social Security Administration's award of a large IT contract to Lockheed Martin, and specifically the award was to the division of Lockheed Martin that was also in the process of being sold to Leidos. But unlike in the Wiley Labs situation, Lockheed went into extensive detail in its proposal concerning what would happen to the assets in question, and gave the Social Security Administration a lot of comfort that under all circumstances, the assets that they were going to be awarding to were the assets that would actually perform the contract. And just among other things, GAO listed at least 8 specific facets of Lockheed's proposal that gave the Social Security Administration comfort and that GAO deemed reasonable, including, for example, the government IT business that submitted the proposal and that would perform any resulting contract is part of the business encompassed within the transaction. And Lockheed personnel, equipment, technology, or services identified in the proposal would be converted to a subcontract or supply agreements with Leidos, et cetera, et cetera. So the bottom line is there are ways to mitigate the risk associated with this pending proposal problem. Next slide.
So now we're going to switch gears and we're going to talk about M&A transactions involving small businesses. In the government contract space, many sellers either are small businesses and therefore they have small business set-aside contracts, or they recently have been small businesses and during their time as small businesses, they received small business set-aside contracts that they're still performing on. And so the question that comes up is what happens during a merger and after a merger and acquisition when the company is no longer considered small. So as a general rule, a concern that qualifies as a small business at the time that it submits its proposal for a small business set-aside contract remains small for the life of that contract. So if you're small at the time that you submit your bid, even if you organically outgrow the size standards, your revenues increase, you hire a lot more employees, you can still continue to compete for work that's set aside for small businesses under that contract, unless the contracting officer requires size recertification in connection with the task order proposals. Next slide, please. Now, there is one exception to this rule, and this exception comes up in the M&A context. If a concern is involved in a merger, sale, or acquisition, the Small Business Administration regulations state that the contractor must recertify its size status within 30 days of the transaction being final. So you have to let your contracting officer know and recertify your size within 30 days of closing. Next slide.
So the question is, what is the consequence of this recertification? And here it is in this slide, is after the small business or former small business concern recertifies as other than small, agencies cannot count the following for small business credit, and that would be really everything involved in performance: new task orders, amendments or modifications, or the value of options exercised. And next slide. However, and this is pretty key, agencies still can, subject to the terms of individual IDIQ contracts, but the general rule is the agency still can issue new task order awards and amendments and modifications and exercise options. So the general rule is the former small business doesn't lose the contract, but the agency can't claim small business credit. And there's risk there because it is difficult for any contractor to have insight to know whether any given agency or how much that agency cares about that small business credit. And how much an agency is concerned about what its next report to Congress about small business credit will look like. So there's a risk there because some agencies might really care about that small business credit, but as a general matter, contractors can continue to perform, and if you have to figure that if the agency is satisfied with performance, they're going to want to see that continue. So no more slides, but in summary, we set out to answer several questions, and to quickly run through in conclusion, can you sell a government contract? Technically, no, but as we've discussed, there are ways that it can be done. What does novation mean? It means it's involved, it's a process that is connected with an asset sale, not a stock sale, so only an asset sale, and we've described what that process is. How long does it take and who decides? You answered that question. It's unclear how long it can take, but there are ways to ensure that the period is as short as possible. The contracting officer, whether it's the administrative contracting officer or another contracting officer specified in the federal regulations, decides. There are risks that we've described in detail and ways to mitigate them. And and the last question is there a way to structure the M&A deal to account for those risks? And the answer is yes. Again, there are ways to mitigate the risks, and they require a lot of strategic thinking. And that is all from us for M&A in the government contracts space. Thanks very much.
Thank you. Thank you, Alexander and Megan, for joining us today. If you have any questions, please feel free to reach out at the phone number or email shown on your screen. And this concludes the webinar. Thank you.